This presentation is available for MCLE self-study credit. If you would like to receive credit, you must take 3 actions. First, click the Show More text below on our YouTube page. The text will expand and show a link to download the handout materials. Once you finish watching this presentation, please click the quiz link to receive self-study credit. Once the quiz is successfully completed, you will receive a certificate via email within 72 hours. We hope you enjoy the presentation. And now I have a great pleasure of introducing our speakers on today's program, Title IX at 50. First, we have Phyllis Cheng. Ms. Cheng is a neutral at ADR Services, where she mediates employment, civil rights, Title IX, and other matters. She also serves on the mediation panels of the California Court of Appeal, Second Appellate District, and the U.S. District Court, Central District, California, where she leads its mediation practice group. Ms. Cheng has served in the administrations of Governors George Deukmejian, Pete Wilson, Arnold Schwarzenegger, and Jerry Brown. Among other things, she was DFEH Director and FEHC Vice Chair. Ms. Cheng was a partner in private practice, a research attorney at the Court of Appeal, and was a Deputy Attorney General at the California DOJ. The State Bar named her the 2012 Ronald M. George Public Lawyer of the Year. She is Managing Editor of the California Labor and Employment Law Review, co-editor of California Fair Housing and Public Accommodations, the Rudder Group, writer of the Labor and Employment Case Law Alert, and contributor to other publications. Before she was a lawyer, Ms. Cheng was Title IX coordinator of the Los Angeles Unified School District and was responsible for the enactment of California's version of the Title IX law. She received her bachelor and master's degrees from UCLA, her law degree from Southwestern Law School, and her PhD from USC, where she was a James Irvine Fellow and wrote her dissertation on state Title IX laws. Next, we have Elizabeth Kristen. Ms. Kristen is the director of the Gender Equity and LGBT Rights Program and a senior staff attorney at Legal Aid at Work, LAAW, formerly known as Legal Aid Society Employment Law Center. Over the past 20 years, she has worked tirelessly to secure justice for victims of discrimination who otherwise would not have legal representation. Ms. Kristen attended Berkeley Law, graduating in 2001. Upon graduation, she served as a law clerk for Judge Browning on the Ninth Circuit. Ms. Kristen began her public interest career as a Skadden Fellow at LAAW in 2002. In 2012, she was selected as a Harvard Law Wasserstein Public Interest Fellow. In 2015, she received the California Lawyer of the Year award from California Lawyer Magazine for her work on the Title IX high school athletics class action case, Ollier versus Sweetwater Union High School District. She has been named a Northern California Super Lawyer since 2016. In 2019, Fair Play for Girls in Sports, the project Ms. Kristen founded, received an award from 2 California Assembly committees to recognize the work Fair Play has done to bring about gender equity in California schools and park and recreation departments over the last 15 years, especially for girls of color and those from low-income communities. Ms. Kristen has also written and spoken frequently about girls' access to sports, including Reflections on Progress Without Equity, Title IX K-12 Athletics at 50 in the Journal of Gender, Social Policy in the Law, which is forthcoming, co-wrote Unequal Play in the Los Angeles Lawyer with Cecilia Kim, The Courage to Speak Out Against Discrimination in the ABA Women Advocate. Finally, we have Karen Pazzani. Ms. Pazzani is a partner at Young, Zinn, Pazzani, and Sandhu. Ms. Pazzani represents colleges and universities in the Title IX matters, including representing clients in administrative mandamus actions filed by students and faculty, challenging the results of disciplinary proceedings, and representing clients in Title IX litigation. She also regularly advises colleges and universities on best practices for their internal disciplinary proceedings. In addition to her Title IX work, Ms. Pazzani represents and counsels employers in a broad range of employment law matters. She repeatedly has been named a Southern California super lawyer in the field of defense side employment litigation. Ms. Pazzani received her law degree from the UCLA School of Law. She received her Bachelor of Arts degree in psychology from the College of William and Mary, where she graduated magna cum laude. So without further ado, speakers, I pass it on to you.
Thank you so much. It's an honor and a pleasure to be on the same webinar with Elizabeth and Karen, who are experts in their fields. Today, we're going to be covering 4 major topics: the history of Title IX, as well as the parallel California laws, focusing on 2 particular areas that are salient on Title IX today: athletics and sexual harassment, and finally, best practices. I want to tell you that all of the art on our webinar is by Alexandra Exter, an avant-garde woman artist from the turn of the century. And other than that, we only have one other slide with PDFs, which we will go through carefully to explain what's going on there. So Title IX had its genesis during the summer of 1970, when Congress first focused on sex bias in education, and a set of hearings on discrimination against women before a House Education Committee that was chaired by Representative Edith Green. At first, there was not a lot of attention, but by the time a year later, noting the link between educational discrimination and employment opportunities, Senator Birch Bayh introduced an education amendment to combat the continuation of corrosive and unjustified discrimination against women in the American education system. He was assisted and supported by Representative Green and Representative Patsy Mink on the House side. And they worked on the amendments, and Title IX became law. There are only 37 words, which is the title of an ESPN special, which I encourage all of you to watch, which tells you everything about how Title IX began and where it is today. I want to acknowledge that one of the important advocates for working on Title IX in the early years, Holly Knox, who was a founder and director of the Project on Equal Education Rights of the now Legal Defense and Education Fund, or also known as PEER. We're fortunate to have her on the phone, and she is the leader on elementary and secondary education implementation of Title IX. And I also want to acknowledge the late Bunny Sandler, who really was a leader on ensuring that women in higher education had the benefits of Title IX. So Title IX is indeed 37 words, which you see on the screen. I'm not going to read them. You can read them, but these 37 words are extremely, extremely powerful. Title IX applies to virtually all school districts, colleges, and universities as recipients of federal grants, contracts, or loans. The recipients include approximately 17,600 local school districts, over 5,000 post-secondary education institutions, charter schools, for-profit schools, libraries, museums, vocational rehab agencies, and education agencies of 50 states, the District of Columbia, as well as US territories. Now, Title IX covers a range of areas, including the ones listed here. Most people don't realize that Title IX is so broad, but it covers recruitment and admissions and counseling. It covers financial assistance, like getting loans and scholarships. Athletics, of course, which has always been a big challenge area on Title IX. Sex-based harassment, which today is very important, particularly in higher education, but also in elementary and secondary education. Treatment of pregnant and parenting students, discipline, single-sex education, employment. Now, for those of you who are employment attorneys tuning in, this is a great crossover area for you if you are going to be either on the plaintiff side or the defense side regarding an educational institution. It could be public sector, it could be private sector. But wherever there is an employment case regarding an educational institution, never forget about Title IX, because it's an important claim. Non-retaliation is an important area as well. Also, every single educational institution must appoint a Title IX coordinator. It's pretty impossible to implement the law without one. Assurance of compliance when they receive federal aid, as well as having policies and procedures that are accessible to everybody in the institution. Title IX is enforced primarily at the federal level by the U.S. Department of Education, Office for Civil Rights, but the DOJ, for Civil Rights, also enforces Title IX, as well as the Department of Health and Human Services, Office for Civil Rights. Now, every single covered institution, pretty much every school and college and university and anybody and any institution receiving federal aid must designate a Title IX coordinator. So local enforcement is key to Title IX implementation. In California, for public schools, the California State Department of Education, Civil Rights, Title IX, ADA 504 MOA coordinator, that's a very long mouthful of titles. That office and that individual enforces Title IX for California public schools. The community colleges, the Vice Chancellor of Educational Equity and Success enforces Title IX for all of the community colleges. The California State University has a Title IX compliance officer, and the University of California has a system-wide Title IX office. All these individuals are critical for implementing the law. So I wanted to also talk a little bit, again, addressing those of you who primarily practice in employment law. You're all familiar with Title VII of the 1964 Civil Rights Act, which covers prohibition of employment discrimination on all the bases covered here: race, color, religion, sex, national origin. Now, the Department of Education has come out with regulations that state there is no inherent conflict between Title IX and Title VII enforcement schemes, and that will construe Title IX and its implementing regulations in a manner to avoid an actual conflict between an employer's obligation under both those laws. So again, if you have an educational institution involved in any claim on the plaintiff side or on the defense side, be aware that they're not, Title VII and Title IX can actually run together in the same claim. Okay, finally, Executive Order 11246 requires affirmative action for federal contractors on the basis of sex and all these other bases. And contractors are prohibiting from discriminating against applicants or employees because they violate 11246. And basically, the OFCCP, Office of Federal Contract Compliance Programs, enforces this law. And actually, Title IX was initially, some of the language came out of 11246. And this is very important because contractors who violate the law, including violation of Title IX, can be debarred. They may be stopped from doing business with the federal government, and really considering the percentage of federal funds going to educational institutions, that is a very important, viable concern. So now let's move on to California law. Now, this is an old picture of me behind, here's Governor Brown and the end of his second term. This is Floor Majority Leader Mike Roos, that's me. And that's my colleague, Abby Liebman, who founded the California Women's Law Center, and it's a leader on Title IX. These are leaders of California now and Los Angeles now, and some women leaders who worked on Title IX. So in 1982, ancient history, I approached various advocates and I said, I realize California doesn't have its own Title IX law, and I think we should. And as a result, it led to this point. This is a signing ceremony. And why is it that it was so important in 1982 that you even thought about having a state law when we had a perfectly good federal law? Well, that's because at that time, we had the Reagan administration was in the White House, and there was this movement to have devolution of federal responsibility to states. And basically, there was going to be a reduction of the enforcement and interpretation of the reach of Title IX. And in about 1984, but at the start before 1984, the Supreme Court ruled in Grove City College v. Bell, 465 U.S. 555, 1984, that Title IX enforcement, Title IX was only going to reach those specific programs and activities receiving federal funds. That meant if you got federal funds in Program A, that's all the compliance you needed, was for not for the entire system. So that was a huge threat to the implementation and enforcement of Title IX. That is why we came up with state law. And there are about, I would say about a quarter to a third of the states have state level Title IX laws. And based on my research, the states with the best laws have the highest outcome for women in education. Those with some laws have the second best, and those with no laws do the worst. So policies do make a difference. And so what has happened, what is the California Sex Equity and Education Act? It's still called that. If you look at the Ed Code 200, it's still called that. It started out as basically a Title IX law in California. And the only difference is that it prohibited any discrimination if you receive state financial assistance. And that's just about everything if you're in the public sector. So that coupled with Title IX, even if it had been interpreted to be limited to programs and activities, really was able to cover broad protection. It also requires promulgation of regulations by public educational institutions, basically Department of Education, community colleges, California State Universities, and University of California. A few years after the law was enacted, I worked with the Senate Education Committee when I was in the Commission on the Status of Women on holding oversight hearings on what these institutions are actually doing. Some of them actually started issuing regulations, and one specific one did not. And as a result, the law was amended to strengthen and requirements on promulgation of regulations. Now, just like federal law, there are companion state laws that council should be aware of if you're litigating in state court or federal court. But basically, if there's a Title IX violation, there's likely a sex equity and education violation. And under the Unruh Civil Rights Act, educational institutions are, well, any kind of public accommodation, all the ones listed here, are prohibited from discrimination on basically all of the bases we had talked about before. Educational institutes, in my interpretation, have been included all along. But there's been some challenge to that. And currently before the California Supreme Court, Brennan v. Superior Court, here's a citation. Review is granted, and the Supreme Court is going to be coming out with a decision soon to interpret whether educational institutions are public accommodations and business establishments under the control of the Unruh Civil Rights Act. So if you have a case, you should be very aware of the Unruh Civil Rights Act, because each violation, when it's sex discrimination, is $4,000 statutory damages. And it's possible to have treble damages. So this is very important to remember, that all of these laws run together. Of course, everybody who's an employment attorney knows about the California Fair Employment and Housing Act, which is a very strong law, and you can get, punitive damages and so forth. So whenever you have a Title IX violation regarding somebody who is an applicant, a volunteer, an employee of an educational institution, just like Title VII, the FEHA would also apply. Finally, like the federal government, the executive order, in California, we have government code sections 11135 to 11139.8, which are currently being enforced by the Department of Fair Employment and Housing. And just like the federal executive order, anyone receiving state financial assistance, whether it's funding or using facilities or contract or loans or anything like that, These institutions, if there is a violation that's found, they can also be debarred from receiving state financial assistance and debarred from doing business with the state. So these are all very, very strong existing statutes that everybody should remember when you have a case regarding Title IX. So now we're going to move on to athletics, and I'm going to hand it over to Elizabeth.
Thanks so much, Phyllis, and thanks to ADR Services for making this training available and available for free, which is really amazing. What I find, and I practice predominantly in the area of K through 12, I find that some of the school officials really struggle to find accurate, free information about their obligations under Title IX. So I'm delighted to talk about athletics today, and let's go to the next slide. And before we start, I just wanted to remind people that this is about more than fun and games. This is an educational opportunity for girls. And there is a lot of research out there that girls who play sports have better physical and mental health, not only while they're playing, but later on in life, that they achieve better grades, they're more likely to graduate and go to college, and that they're more likely to graduate when they receive college sports scholarships. More than 80% of executive businesswomen played sports. And my favorite statistic, high school female athletes make 7% higher wages later on as working adults. So this is also about dollars and cents. And it's really important to remember that this issue of educational equity with respect to athletics matters a lot. Next slide, please. So it's the 50th anniversary of Title IX, and it's good to look back to 1972 and know that at that time, fewer than 300,000 girls participated in high school athletics. And today that number is more than 3 million, but that number is still less than the number of boys that were playing sports in 1972. And so we'll talk more about athletic participation opportunities and the requirements for equity that Title IX has. But even though girls are about 50% of the student body, they do not get the full share of athletic opportunities, just 42% of the athletic opportunities. So that amounts to hundreds of thousands of girls who are not having a chance to play sports on an equal basis as boys. Next slide, please. So where there are difficulties and problems with Title IX, there are a number of different avenues that students and parents and coaches have available to them. They can complain directly to their school or their school board, and there's definitely been some examples of great success where communities were able to rally and use that political lever to make sure that they achieved equity and change at their school. People can sue in court through private lawsuits. These are challenging because we're asking parents of high school minor children to come forward and be litigants in a pretty public case against their school, and parents and students fear retaliation. And we'll talk a little bit more about how retaliation is prohibited, but unfortunately, that doesn't mean that it doesn't happen. Folks can complain to the U.S. Department of Education, and they will investigate Title IX violations. Folks can complain to a governing body of athletics like the California Interscholastic Federation, and there can be complaints to the California Department of Education. And so there are a lot of different avenues available. They all have their pluses and minuses, but I wanted to put that out there as well. Let's move to the next slide, please. So Title IX has three main requirements that I'm going to talk about today. The first is the equal opportunity to participate requirement. I'll explain more what that means. Also, schools have to provide male and female athletes with equal benefits and treatment. And this is an overall look at the entire athletic program and all of the different components of it. And there's supposed to be no retaliation. Next slide, please. So with respect to equal athletic opportunities, the institution has to look at the selection of sports and the level of competition and whether it effectively accommodates the interests and abilities of both sexes. And you will see that a lot of this language developed where we were really talking about a gender binary. And I don't think the Title IX athletics world has yet completely adopted and adapted to a world in which we do not have a gender binary, and that's becoming more and more clear to folks. And so this is still an evolving issue and an evolving area of law. Let's move on to the next slide. So I want to talk about the three-part test and explain how the test works. So the first part, and I think the most important part, is proportionality. And here what we look at is the athletic ratio compared to the ratio of student enrollment. I'll explain more about what that means. Now, assuming a school does not meet part one of that test, which they often do not, a school can assert an affirmative defense that they have a history and continuing practice of expanding athletic opportunities for the underrepresented sex, which is almost always girls. And so maybe in 1972 or 1975, this might have been a viable defense for an institution, that they'd sort of been steadily adding opportunities and adding sports opportunities. But we don't see that today. What we usually see now is cutting teams, and that's why these cases are coming forward. And so I think most of the time, this affirmative defense is not effective for institutions. The final part of the test allows an institution to show that they are fully accommodating all of the interest in the underrepresented sex. So say there is a gap between the number of girls enrolled in school and the number of girls participating in athletics. A school can try and show that they've surveyed all the girls in the school. Girls have no interest in participating in sports in any greater numbers. Again, this is not a very effective argument for schools, because what we find, at least at the K-12 level, is that schools have not surveyed their students, so they just don't know. And when they do survey their students, they find out that girls do want to play sports in greater numbers. Next slide, please. So I want to talk a little more about substantial proportionality, just because I think it's the most important part of the three-part test. It can be really difficult to find the data at the high school level. And so I have a link here on the slide to the California Interscholastic Federation. There is a law in California that requires that schools report their participation data. And so the CIF data is available, and I'll explain a little bit more later what it looks like as raw data and how we have put it into a spreadsheet to really look at how schools are doing in California. But basically what you want to look at is that enrollment percentage and then the participation percentage. Yes, next slide. Thanks, Phyllis. So the history and continuing practice defense, I'll just skip over the slide. Please look at it later, but I don't think it's a very viable defense for most schools. Next slide, please. And again, the full and effective accommodations, if schools really want to rely on this part of the test, they need to be doing a very active job at checking in with their student body about what they're interested in playing and trying to really show that they are accommodating all the interest. Next slide, please. And so I put in a mathematical example to show people what participation opportunities look like. We also have a calculator on our website at Legal Aid at Work, our Fair Play for Girls in Sports project. But basically in this example, it's showing that girls are about 50% of the enrolled students, but they are not 50% of the athletic program. You can see there's only 70 female athletes out of a 200 total. So there's 35% of the athletic program is given to girls, which means there's a 15% gap. Now that's a gap between the percentage enrollment and the percentage participation. The percentage gap alone is not the end of the story. You could imagine a tiny, tiny school where 15% gap might be a very small number, and you could not add a new team or even a new level or even add additional players to a team. But at most schools, this is going to be a significant number. And in this example, there would be 60 more girls who could play if there was participation equity. And so what this means is that there is a violation under prong one. And I will often bring a motion for summary adjudication when I see these kinds of numbers, because I think the school will not meet the other two parts of the test. And there's cases out there about a 6.7 participation gap and a 3.2 participation gap. Again, not just on the percentages, but on the actual numbers. Sometimes schools think there's a safe harbor, like, oh, if it's just 2% or if it's just 5%, we're okay. That's not true. You have to actually look at the number of girls that would be participating if there was equity. Next slide, please. And so this is an example of the California Interscholastic Federation data that we have put into a spreadsheet. This is an example of 2 schools in California. It shows the total number of enrolled students, those that are boys, those that are girls, that percentage, and then it makes the same calculation on athletes, how many boys, how many girls. Then it calculates the participation gap as a percentage, and then it turns that back into an actual number of girls who would be participating if there was equity. And so you can see these are different. One it's 16, one it's 50, but I would say that in almost all the data that we've looked at, there is a participation gap. Next slide, please. Equal treatment and benefits has to do with everything else in the athletic program. This is also supposed to be equal. So we're looking at facilities, equipment and supplies, scheduling of game and practice times, travel and transportation, coaching, publicity, medical and training services like weight rooms, things like that, recruitment, fundraising opportunities, scholarship dollars in college, and then housing and dining at the college level. And so in the equal and treatment and benefits component, you're really looking at the overall program. What I see often at the high school level is that the football program has almost exclusively boys and it's treated extremely well, usually. And then there's a softball, baseball disparity. So baseball is treated very well. Softball is not treated very well. Maybe they have terrible field, off campus, no exclusive use. And so we see violations often there. We also will see, especially at some older schools, that they will have an athletic locker room for boys only, and that girls will be relegated. In our case that we have going on right now in Hawaii, girls were relegated to changing under the bleachers, to going to a local fast food restaurant. They just did not have access to an athletic locker room. And so that's another kind of Title IX violation that we see. Next slide, please. And so we can skip through these facilities slides. It's just a reminder that you look at all different kinds of access to facilities. So you look at locker rooms, storage areas. Next slide, please. You look at uniforms and equipment. Next slide, please. Travel. We often will see buses being provided that are much nicer for the football players than for the softball players, for example. Accommodation, dining allowances. What we see at the high school level is the end of year banquet. And for the baseball team, it's held, at a fancy hotel, and the softball team is having their banquet in the cafeteria. Next slide, please. The main thing, and we'll get to this on best practices, is that schools have to really also look at the booster club issue. There's a lot of different money coming into schools from private sources, and schools will sometimes say, well, we don't know what the booster clubs are doing, and therefore we aren't responsible. And schools have to really be careful about that. So I will pass it to Karen. I see I have some questions in the chat. I'll do my best to answer those without taking up Karen's time. Thank you, Karen, and thank you, Phyllis.
Thank you, Elizabeth. I appreciate it. So I'm going to address how schools deal with sexual harassment under Title IX. And it's interesting because when we were prepping for this presentation, Elizabeth mentioned that at first, I think when Title IX was enacted, really the big piece was athletics. And that's what most people thought about when they thought about Title IX. And now I think that's switching a little bit. And now people are starting to think more about how Title IX impacts sexual harassment within schools, which includes universities and basically high schools, and it addresses all schools, but I don't think you see too much sexual harassment in elementary school. I could be wrong. I deal with the universities mostly. So when Title IX was first enacted, there was not a lot of regulation regarding how schools were supposed to address sexual harassment. There was just a regulation that said schools were supposed to have grievance procedures and didn't really explain what that meant. So there were some guidance that discouraged adversarial models of addressing allegations of sexual harassment. So based on that guidance, a lot of universities and a lot of schools developed a single investigator model where they investigated allegations of sexual harassment by having an investigator interview the witnesses, interview the parties, and then make a decision based on that. And in August of 2020, the Department of Education enacted new regulations that required a much more adversarial process for investigating and addressing these types of allegations, and also interestingly narrowed the definition of what sexual harassment is. And we'll talk about that a little bit more. Most recently, in June of this year, the new Department of Education, because the administration has changed, has issued proposed new regulations that actually expand the definition of sexual harassment, but potentially change the way schools are required to address them, and make it a little less adversarial. So those proposed regulations are currently under review, and they're subject to public comment until September 10th. So if anyone is interested, you're welcome to comment, review those regulations and comment on them. Next slide, please. So currently under Title IX, the definition of sexual harassment is actually fairly narrow and narrower than California law. So it prohibits what is essentially what we know as quid pro quo harassment. So an employee conditioning provisions of aid or benefit on participation in unwelcome sexual conduct. It also prohibits unwelcome sexual conduct determined by a reasonable person to be so severe, pervasive, and objectively offensive that it effectively denies a person equal access to the educational institution's program or activity. And that's where you'll see the employment practitioners in the room will see that that's actually a narrow definition than what California has for sexual harassment. And then it also precludes sexual assault, dating violence, domestic violence, or stalking. Next slide, please. So under the new proposed regulations, assuming they are enacted, again, quid pro quo sexual harassment would be prohibited, but the hostile environment has changed. It would be defined as unwelcome sex-based conduct that is sufficiently severe or pervasive that based on the totality of the circumstances and evaluated subjectively and objectively, it denies or limits a person's ability to participate in or benefit from the institution's education program or activity. So that's a more expansive view of what would be considered sexual harassment. And again, it would prohibit sexual assault, dating violence, domestic violence, and stalking. Next slide, please. And the new proposed regulations would also expand the characteristics that are considered sex-based harassment. So sex-based harassment could be based on sex stereotypes, sex characteristics, pregnancy or related conditions, sexual orientation, or gender identity. So that's new, and if the proposed regulations are adopted, that would be, again, an expansion of the definition of sexual harassment. Next slide, please. So under the current regulations, what schools are actually required to address is also somewhat limited in terms of jurisdiction. So schools are really only required to address sexual harassment that occurs within the United States and of which they have actual knowledge, which means the Title IX coordinator has knowledge or an individual with authority to institute corrective measures has knowledge. And schools can actually designate who is an official with authority to take corrective measures, so they can somewhat limit who would be someone who would have actual knowledge of the harassment and require a response. Next slide, please. So under the proposed revisions to the regulations, schools would be required to take action when they are on notice of conduct that may be sex discrimination. And that generally means that employees who are not confidential employees are required to notify the Title IX coordinator when that employee has information that conduct may constitute sex discrimination under Title IX. So it's a broader requirement of who has to notify the Title IX coordinator and when action is required to be taken. We've also seen an expansion potentially of the conduct that is subject to review by the schools. It would now not just be within the United States, but any conduct that is subject to a recipient's disciplinary authority. And usually schools and universities have a process where they will potentially investigate and discipline students for conduct that occurred off campus or occurred in study abroad programs, which would be outside of the United States. So if those schools have taken over that disciplinary authority, Title IX would then apply there as well under the new proposed regulations. Next slide, please. And then in terms of the grievance procedures, as I mentioned at the beginning, the current regulations require a fairly adversarial process for addressing allegations of sexual harassment. So it's a very detailed process that's required, and it's essentially notice to the parties, an investigation of a formal complaint that's made, an opportunity for the parties to review and inspect the evidence. Then there's an investigative report that's provided to the parties, which the parties are allowed to review and respond to. And then there's actually a live hearing before a neutral adjudicator where the party's advisor is allowed to ask questions to the witnesses and other parties. So there's this mini cross-examination that actually occurs during these live hearings, and that's required by the current regulations. And then there's a written decision and the opportunity for appeal. Next slide, please. And under the new proposed regulations, if they're enacted, there would be two different grievance processes for addressing allegations of sexual harassment. And those would be to address allegations that are against faculty, non-students, staff. And then there's a more robust process when the allegations involve students. So generally under the sort of generic process that would involve faculty, staff, and employees, there would be a requirement of notice of the allegations, adequate and reliable and impartial investigation, a procedure to provide a description of the evidence to the parties and an opportunity to respond, and a notice to the parties of the outcome. The appeal is optional, it's no longer required potentially, and then the process must be complete before imposing sanctions. So under this new proposed regulations, we could potentially see schools going back to a single investigator model and not using a live hearing. Next slide, please. And then when students are involved, there's again a slightly more robust process that's required. There's expanded notice requirements, which means the students are required to get notice of the school's policies, a little more robust notice of the policies, that the respondent is presumed not responsible, and the rights provided to the parties during the process. And then there would be an investigation, equal treatment of the parties throughout. And in the student process, there's the ability for the schools to use either the single investigator model or a live hearing. So let's go to the next slide. So if an investigator is used under the new process, there would have to be equitable access to the evidence. And if a report is made, equitable access to the evidence upon request. So the access to the report and then also the evidence upon request. A reasonable opportunity to review and respond prior to a decision. And if credibility is at issue, individual meetings with the investigator where the investigator asks questions of the parties to assess credibility. And the investigator would ask questions that are proposed by either side. So the respondent would know what the complainant had initially said and would ask the investigator to ask certain questions, a semi-cross-examination. Next slide, please. And then if there's a live hearing, it looks a little more similar to what we have right now. Whereas again, there's the opportunity to review evidence in the investigation report, the opportunity to respond before or during the hearing, and being physically present in the geographic location where the person is, or being present through technology. And again, allowing the parties' advisors to ask questions during the hearing. So that would be different than where the investigator is asking questions. It would be more like cross-examination. And no questioning personally by the parties. This has been a big issue where when parties do not have an advisor, they've at times wanted to ask questions themselves of the other parties, and that would be prohibited. And actually schools would be required to provide an advisor without charge to any party that does not have one for the purpose of conducting cross-examination. Next slide, please. So this is just a brief notation about some cases that I think you might want to look into if you're interested in this area. Once a school has addressed sexual harassment, there's opportunities for if a person was found responsible for sexual harassment, opportunities to get court review through a petition for writ of mandamus. And that's what the Doe versus Regents of University of California case, the 1918 case, addresses, is the standards that are used when a petition is filed to ask for court review. And essentially the courts are looking at whether the procedure was fair and whether or not the findings are supported by the evidence. And then there's also an opportunity to file a lawsuit for damages under Title IX. And that's the first two cases on this slide. We'll explain what the elements are of those. And recently, essentially, the courts have found that if a respondent is suing and seeking damages under Title IX, what they would need to plead is that the disciplinary process showed gender bias. But if the complainant who is potentially subjected to sexual harassment is suing, this is the Karasek case, they need to show deliberate indifference in their pleading, that the school was deliberately indifferent to the sexual harassment. So then I will actually go to the next slide and hand it back to Phyllis to talk about some best practices.
Thank you so much, Elizabeth and Karen, both. So we're going to talk about best practices, looking at kind of just basic things. Educational institutions, or if you're looking at a case as a plaintiff's attorney, if you're looking at on the defense side, you need to ensure that there's been an appointment of a Title IX coordinator who is readily identifiable and accessible. So it just shouldn't be a title that's tacked onto and everything else to say some administrator. There should be an identifiable Title IX coordinator, a way to contact that person, and that person should be visible. Ensure that the Title IX coordinator is trained on Title IX, parallel state laws. Just because somebody has a title, you've appointed somebody, doesn't mean that they are knowledgeable, because when it comes down to investigating or looking at a case, looking at compliance, that individual needs to be well trained. Ensure that the Title IX and parallel state law policies and procedures are published and accessible. So many times they're student handbooks and the like. Definitely Title IX and these parallel state law policies should be as part of that, that student handbook or whatever is posted online. Ensure that the educational institution files assurances of compliance when applying for federal and state financial assistance. They're all supposed to do it, and that actually is a very important piece of evidence. And then ensuring that grievance procedures comply with the statutory requirements, given that we're anticipating new Title IX grievance regulations that impact the grievance procedure. Take a look at both the current ones and the upcoming ones to ensure that the statutory requirements, both present and future, how they're impacted. So I'm going to hand it back to Elizabeth for best practices in athletics.
Thanks, Phyllis. You all could see that I was very interested in the athletic participation numbers. So I would recommend any institution do that and look at their athletic participation numbers and survey students to see what additional sports girls want to play. You also want to look at your athletic facilities and look at the gender equity issues. And if you can't survey them all on one day, make a plan to look at all of them. But I would recommend starting with the weight room, starting with the athletic locker rooms, looking at the softball and baseball facilities. Those are the areas where I often see the most visible disparities. Then you want to look at the publicity that your school is providing for athletics. Look at the yearbook, the school newspapers, the assemblies, all of those areas where the school is providing publicity for athletics. And then training, make sure that athletic directors and coaches and your Title IX coordinator are well trained in Title IX and school practices. And then I mentioned before about Booster Club money. Make sure to be watching Booster Club money and the benefits that it is providing, because it is the school's responsibility. Just as a school couldn't accept Microsoft computers only for boys and then not provide computers for girls, the same principle applies with respect to private donations for athletics. And then make sure there's no retaliation against people who raise Title IX concerns. And I'll pass it to Karen for the next slide.
Yeah, so for sexual harassment, I think as Phyllis mentioned, definitely adopting grievance procedures that comply with the current Title IX regulations. There's also state law, which we didn't have time to get into, but you want to make sure that the grievance procedures comply with state law as well. And then begin considering revisions based on the proposed regulations. We don't know that they will be instituted in the way they are currently drafted. I think it's likely that they will be, but there is the opportunity for public comment, so there might be some changes. And then just generally really ensure a timely response to reports of sexual harassment. The biggest problem I see in my cases is when a timely response hasn't been made or when an investigation has dragged on for too long. So really just making sure you're being diligent about responding to reports of sexual harassment and also maintaining clear documentation of the response to sexual harassment. A lot of times we'll have a fantastic investigation, a fantastic outcome, something really was done, but documentation is not as clear as you would like it to be. And so maintaining that documentation, making sure you're noting if there were delays, why there were delays, and what you were doing and how you were being proactive is very helpful.
Okay. So before we move to answer your questions from the chat room, I just want to give you the last slide has all of the speakers' contact information. We'll try to answer all of your questions on chat, but if we cannot cover everything, feel free to reach out to any of us. So I'm going to stop sharing the screen now and we'll move on to answering questions. So let's see. One question is, Karen, can you speak to the role of a public school district to prevent harassment by its minor students against a district's employees or students?
So preventing harassment by students against the employees, is that the question?
It seems to be the.
Yeah, so I work primarily with colleges and universities, so I don't have as much experience with public schools and secondary schools, but I think most likely it would apply across the board. So Title IX does prohibit sex discrimination across the board against employees and against students. So if there was harassment by students against employees, that is something that would need to be addressed as well.
Okay, thank you. Elizabeth, do you have anything to add to that? All right, the next question is, also please address damages and or liability of educational institutions for students, for student-to-student sexual harassment included in primary schools in California. Student-to-student sexual harassment.
That's actually a very timely question because there's a recent Supreme Court case that has found emotional distress damages are not actually available under Title IX. You would only be able to get what are contract damages under Title IX. However, that's based on the spending clause. So I don't think that will apply to the California equivalent of Title IX. So I think potentially there's additional damages that are available under California law that wouldn't be available under Title IX.
Right. Next question, what about sexual harassment allegations that occurred in 2020 prior to August 2020 date when things became more detailed?
That's also an excellent question. There has been some case law that holds that if the complaint was made prior to August 2020, the old procedures can apply. So the old procedures would be potentially usable in that case. But again, you also have to look at state law and make sure you're complying with state law. And there's been a lot of state law in California about what is a fair process. And in general, in California, what is a fair process right now means some type of live hearing with some type of cross-examination when credibility is at issue. So you want to look at those things as well.
Okay. Another question is deliberate indifference standard applicable to primary and secondary schools?
Yes, it is. The same standards applies to primary and secondary schools.
Okay, so the next question is, does Title IX apply to private Catholic schools? I'll take that. That it's exempted. Religious educational institutions are exempted, and they're also exempted generally under employment law. Next question, what about the impact of Cummings v. Premier Rehab Keller, U.S. Supreme Court case about section section 504? Is anybody familiar with that here?
Yeah, so that's the case that I mentioned where the Supreme Court has found that emotional distress damages would not be available under Title IX.
Okay, next question. Are private high schools mandated to provide equal educational instruction to those who are mandated to quarantine given the new COVID guidelines, such as online learning access via Zoom or other methods? What about the damages? Can they include emotional distress caused by the impact on that student's educational programs and retaking of courses they have failed? It's an interesting question. Anyone want to? Well, let's see. COVID, some of the COVID quarantine issues and online learning, they're so new that I think that there's really no case law at the time. But educational institutions, I believe the California Supreme Court will rule that schools are business establishments. And so yes, it's possible that maybe, say a student had COVID or had some kind of disability, and maybe that could be covered under the Unruh Civil Rights Act, but it's really an area of the law that is still in the process of being developed. But those are excellent questions. Okay, so next question is, are religious schools also required to provide non-discriminatory actions even if it violates the school's religious belief? Religious schools, again, are exempt under Title IX and state law. Okay, I think those are, do we have other?
I think there were a few earlier questions on the athletics piece if you scroll up.
Oh, okay, sorry about that.
I've been trying to answer those in the chat, so hopefully I got through all of them. There was a question about getting more information about the application of booster clubs, and so I put in the answer, a link to the OCR letter on booster clubs. And there's also a law review article I found about booster clubs. There was a question about requiring girls to play sports to get to equity. And I sort of reframed that into, you want to encourage and survey and check in with the female students to see about their interest in athletics. And there's a number of really good resources out there, including from Positive Coaching Alliance and Voice in Sport, about how to make sure you're reaching out to female athletes. And then I had put something in the chat, Phyllis, about the religious schools as well, just something from OCR's website. And then there's been some interesting case law, I think, about the recipients of PPP money and for how long would a private school, for example, be potentially subject to Title IX and other federal law because they received PPP money. And that, I think, is still an emerging area of law.
Thank you. So taking a look at trends, both of you are actively involved in litigation involving Title IX. Do you see, Elizabeth, for example, on the plaintiff side, do you see a growing number of cases regarding Title IX and the state law violations?
I mean, I feel that there is, unfortunately, rampant violations of Title IX athletics mandates at the K through 12 level. And if there were more lawyers to bring these cases, there would be more cases. But unfortunately, there's a very small group of lawyers that bring Title IX athletics cases, especially at the K through 12 level. And so I think that the violations are getting potentially a little more attention because of the Title IX 50th anniversary, but the violations are there for really anybody to find. And I think that what I've seen is that there's almost a culture of acceptance of the way in which athletics has favored boys over girls. And so everybody, all of us, all of the community members, teachers, coaches, parents, other members of the community need to be involved looking at these issues.
Karen, what kinds of cases are you seeing as a defense counsel?
So we see cases that sort of run the gamut. So we work with universities, whether they're being sued by a respondent or a complainant. So we see a lot of litigation from the respondents dealing with the fairness of the process and addressing what that is. And that's, as I was talking about, that's really varied throughout the years, what is considered a fair process, and it's changing and it's politicized. So it's potentially changing again. So I think there will continue to be quite a bit of litigation in that area around fair process. And then we also see, allegations that someone who was harassed was not treated properly and that not enough was done. And I think that will also continue. I think we're a litigious state, we're a litigious environment, so I don't see it slowing down.
ADR Services, Inc. has been your unwavering partner in alternative dispute resolution. But as the world changed, so did we. From virtual and hybrid hearings to our ongoing on-demand CLE program, ADR Services, Inc. continues to keep resolution and legal education at the forefront, woman-owned and operated from the start. There is someone for every situation. We are ADR Services, Inc.,